You know what to say now. Hello, everybody. My name is Annie, and I am the support group leader along with my co-leader who's here today also. And welcome, all of you. We are at the Crozet Library just outside of Charlottesville. And we have a special guest here to speak with us about disabilities in the workplace. I did want to mention before we start that I want to make sure that, well, that's probably too far away, that you're all aware of the fact that there's a conference coming up in June. That's the national conference that Hydrocephalus Association has every other year. So we're in an on year, and it's in Minneapolis this year, June 16th to the 19th. And so I gave out some brochures. If you're interested, it gives you the website, and you can go check at the website as to what's going on and how you can register. So thank you. We are here today with Wells Harrell, who's an attorney in Northern Virginia area. Am I correct on that?
Practice in Washington, live in Northern Virginia.
Very good. And he's here to speak to us today. And I'm very interested in the topic because it's something that is just not universally known in terms of what our rights and responsibilities are as people with hydrocephalus. And so I'm going to turn it over to you, Wells, and then we'll have a bit of a Q&A.
All right, sounds great. Well, thanks so much for having me here, and thanks to Annie and Kaylee for organizing this. This is great. So I'm Wells Harrell. I am an attorney in Washington, D.C. I work for Boys, Children, and Flexner. We're several hundred attorneys strong. We have offices all over the country. We specialize in complex litigation. So disability isn't one of our firm's main fields, but a lot of us there do have some experience with disability cases. I'm one of them. So I'll give you a little bit of background on how I first got to be involved with disability law. It was a few years ago. We got a case by a former federal employee who had a variety of ailments. She had very bad lower body arthritis, and she had a respiratory condition that made it difficult for her to breathe. And she asked her employer for accommodations repeatedly, and every time the answer was no. If it was something simple like a printer near her desk, it was no. If it was something like, well, can you give me a parking space so it's easier for me to get to the office? No. Could you let me telework a few days a week? No. So we took that case all the way through. We were 4 days away from trial, but we managed to get a very, very good settlement, and now our client is much, much better off. It was an intense case, and it got me very familiar with at least the basic outlines of federal disability law, as well as some of the nuances and issues that can come up. So thanks again for having me. I don't really have a presentation to give, PowerPoint and everything, but I at least wanted to touch on a couple of topics. So I've got it kind of structured in three parts. One is, what is the definition of disability under federal law? Two, what are your rights when you're applying for a job? And three, what are your rights once you have a job and you're employed? So the first is, what is disability? What does it mean? Now there's each state has its own set of disability laws. Many of them are modeled after federal law, some of them aren't. So for state-specific questions, those aren't ones that I came ready to talk about, but I'm very familiar with federal law. And under federal law, disability is defined as a physical or mental impairment that substantially limits one or more major life activities. So to break that down, a physical or mental impairment can be anything, any kind of condition, any kind of thing that you have that affects you physically or mentally. So the other part of that, major life activities, very broad. They include everything from walking, lifting, eating, seeing, talking. So physiological activities, so body functions like your circulatory system, respiratory system, neurological system, as well as mental functions like thinking, concentrating. So for the longest time, the question would be whether something is substantially limited, whether a major life activity is limited enough to qualify as a disability. Congress came along in 2009 and said, let's expand the scope. So courts have been saying before that, oh, substantial limits it's a pretty big standard. And the legislature came along and said, no, let's expand the definition. So now the instruction to courts is to construe substantially limiting maximally in favor of broad and expansive coverage. So the primary federal law is the Americans with Disabilities Act. That was amended to expand the scope of the coverage a few years ago. So to wrap that all up, the short answer is that disabilities is treated very broadly. So for your purposes, what you might be wondering is hydrocephalus a disability? And the answer is it can be, yes. My understanding is that it can affect people in a variety of different ways. But to the extent that it's a condition that you have, so it's a physical condition, it affects a bodily function, and it's even occasionally affects your ability to concentrate or think, then that is a substantial impairment of major life activity, and therefore it can be a disability. And one important part is that the mere fact that you have symptoms only some of the time, it can still be a disability, because the law says that something is a disability even if it's in remission, if it substantially limits a major life activity while active. So that's the key. So if you have a condition like MS that tends to come and go in terms of symptoms, I understand that hydrocephalus can be very similar to that. Then if it's active and it impairs your ability to think, either giving you headaches, blurred vision, other kinds of symptoms like that, then yes, it can qualify as a disability. So that's the short answer there. So the next topic is, well, so you're a person with a disability and you're applying for employment. What do you have to do, and what does your employer have to do? Well, the law is very interested in protecting people's privacy. So one of the key purposes of disability laws is to make sure that disabled people enjoy the full privileges and benefits of employment. And one of the ways in which it does that is making sure that they are not placed in situations where they have to reveal more about the medical condition or disability they're comfortable with. And by the same token, making sure that their employers, the people they're either applying to or actually employed by, don't make unfounded judgments about them. Don't judge them based on stereotypes about what people with disabilities can do or can't do. So one of the ways in which the law accomplishes that is to protect your privacy. So one question is, do you have to tell an employer that you have a disability or any kind of medical condition? The answer is no, you do not. In fact, the employer can't even ask you before giving you a job offer. So that's an important point. So if an employer asks you, are you disabled, or do you have a medical problem that would keep you from doing the job, before giving you a job offer, they can't do that. It's prohibited. So let's say that you have a job offer. Things change a little bit, not much, but a little bit. At that point, an employer can say, all right, so here's a job offer, but in order for you to start, we need you to take some medical tests or answer some medical questions. Can they do that? And the answer is yes, but they can, as long as it's the kind of thing that they do for applicants generally and for other employees generally. So they can't just single you out because they think you might be disabled. So if it's the kind of job where they customarily do medical questionnaires, etc., as a condition of taking the job, that's one thing. They can do that within reason, but they can't simply say, oh, well, you look like you might have a disability, so I'm going to run you through the gauntlet. It's not something that they can do. If during the application process you volunteer that you have a condition, like hydrocephalus or something else, even there, the employer has to be very careful. Because they can't, again, they're prohibited from asking you if you're disabled. So even if you're an amputee, they can ask you general questions about whether you can perform a job. They can ask you general questions about whether you might need an accommodation for the job. But they can't say, it looks like you are an amputee. How does that limit you? That's off limits. And it makes good sense, right? It makes sure that employers are asking the right questions, making sure that they keep their information gathering sort of strictly necessary to what they need to know before bringing you on as an employee, and not letting them stray too far, not letting them make you uncomfortable with questions of medical nature. All right, so you accept the job offer, you start, you're employed there. One thing you might ask yourself, before taking a job, or if your symptoms happen to get worse, is ask yourself, do you think you need some kind of modification at work in order to do your job? And if the answer is yes, then there's a process for that. It's called the interactive process. It's something that the law says that employers have to do. They have to engage with you if you come and request an accommodation. And ultimately, if it's reasonable, and if it doesn't pose a threat to anyone else, and if it's not too much of a burden for them, they have to give you an accommodation to let you do your job. So that's the basic framework for reasonable accommodations. And it works well for everybody when it works, because it means that disabled people get to do their jobs, as long as they need reasonable, not unduly burdensome modifications to do it. It means that they get to enjoy employment, and the employer gets to keep a productive employee. So it works out well for everybody. That's how the law is supposed to work. And reasonable accommodations are how that happens. So let's say that you start a job, you have a disability, but you're asymptomatic. It's been under control for several years. Let's take epilepsy as an example. So you haven't had a seizure in a long time, but there's a risk of it. You don't have to tell your employer that, at least under most circumstances. It all depends, it's all case by case, it all depends on the risks involved. Because the law does say that the employer can take appropriate action if employing you presents what's called a direct threat to your safety or someone else's safety. And you can imagine that there are certain jobs where certain people with certain medical conditions just might not be qualified for, especially if the condition tends to manifest without warning, and then just depending on the job and depending on the condition. But at the same time, if you are a person with a disability and you go to your employer and you say, I need some help to do my job, I might want an accommodation, the employer has to work with you, and they have to find some way, if it's at all possible, to let you do the job that you're otherwise qualified to do, and find the right accommodation for it. So it's a flexible process, it's a give and take process. We can talk more about it in the Q&A session. But to just summarize overall, if you're a person with a disability and you're in the workforce, you have a right to ask for accommodations. It doesn't have to be magic words. You don't have to use the words reasonable accommodations. But if you think at any point you might need some adjustments at work to do your job, then as long as keeping you on doesn't present a direct threat to anybody, and as long as you can find some accommodation, some adjustments to your work schedule, some possibly an alternative position, possibly something as simple as an ergonomic chair, just depending on what the condition is. As long as you can find that with your employer, and as long as it's not unduly burdensome for the employer to give that to you, then they have to. So I guess I'll just wrap up by saying that, and I hope to get a couple of questions about it, because the process can be it varies case by case, but you shouldn't feel shy about asking for accommodations if you need them. Now, in the course of that, employers have to protect your privacy, and they have to keep your medical information in a separate file. They can make reasonable requests for medical information if they think it's necessary to substantiate that, yeah, you really do have impairments, and that it's helpful to give you an accommodation. But and so I'm happy to answer some specific questions about how that process works. But the takeaway is that it's right. that you're a disabled person, you need an accommodation to do your job. It is certainly your right to ask. Your employer can't retaliate against you for asking. They can't discriminate against you once they know that you have a disability. And if there is an accommodation out there that's reasonable, then they have to give that to you. So I guess without further ado, happy to take questions.
That's been the difficulty for me, is not knowing what your rights and responsibilities were, what kinds of questions to ask you. But Kaylee, do you want to take a little bit of break? I'm going to check with HA and make sure the sound is okay. Let's take a 5-minute break and then we'll continue with you.
All right.
Thank you so much.
How does this work? Are you recording and then you'll put it on the site?
It is actually streaming live right now.
How impressive. How wonderful.
Yeah, thank you so much. Help yourself to some food, and I'm going to ask if they turn the temperature down a little bit.
Yeah, it is a little warm.
It really is.
Where's his phone? We can get questions for this one.
We actually did questions.
Yes, like around there.
He was diagnosed at 3 months. They went out to the park. They were no boarders. But he was diagnosed at 3 months and we were there. And so far, he's got more shots and he's doing great. And it's really sort of miraculous that way. But and he's doing great. He knows the rest of it. And I think the reason that is because we actually found out before he had the symptoms at the little child visit. They measure their heads, and this was in bigger. Just also funny because we just have big heads.
Look for someone with a tent.
I know. My pediatrician really caught it, and we were just really lucky. So he went into surgery with less damage. I think what happens in a lot of cases is, that fluid builds up and your brains are, damaged. There's a boy in our group in Richmond who's had, I think he's on 20 brain surgeries now and has hearing problems and, developmentally he's walking, so he's just a year younger than Helen. And he's assisted walking now, so he has this contraction, although he started on his own. So yeah, it's a tricky, what's funny about hearing you trying to, how people can be disabled is so broad.
It is, yeah.
And hydrocephalus in particular is so broad. Every case is so different. Like maybe you have normal pressure hydrocephalus, right? And so that it's still hydrocephalus, but it manifests so differently than what my son would show if he was having a shunt fail. So well, so developmentally, like as they grow, there's windows where there's chances for it to fail, or it's more likely. And he's out of the infection window, so like 2 years out, if you haven't had an infection, you're not probably going to get an infection, is how our neurosurgeon told us. So you're out of that room, but the shunt, like most shunts, 90% of shunts fail within 10 years. Like it's really hot. Like the odds are not in our favor. We're gonna probably have brain surgery again. But then there was a woman that came to one of our meetings who got diagnosed at 3 months and her shunt lasted for like 30 or 40 years.
Oh, wow.
So you never get this definitive, okay, we're out of it. But you don't get to have that.
How about this or this?
Yeah, it's.
Like another way.
Wow, it's just easier to hear.
Yeah, we shifted around and
Common effort. You know, that's all you do.
first time.
I was very fortunate in that I've lived most of my life without cancer or hydrocephalus.
Right.
So now, no matter what happens, I don't have all of it going to go. There's somewhere she has to put up with it.
I'm trying to think of a question. You're not on yet, right?
Yes,
I'm watching it on my phone.
Hi. Welcome back.
Well, welcome back, everyone. We're kind of stuck with having questions in our own minds, not really knowing what the,
But people can comment or something.
people can comment on the HA set, and Marcy will be checking to see which site would you
On
like.
YouTube.
Oh, comment on the YouTube, on the video, and then we can be able to see them and answer questions. One of the things for me, our daughter who is here has hydrocephalus, is I didn't know where the liability lay, and your introduction answered some of those questions. She is applying for jobs very soon, and form-wise.
I haven't interviewed on Tuesday.
Mhm.
And it's like, I don't know, it hasn't been an issue in years. My hydrocephalus. So I don't know. I didn't say anything when I was in college. No one knew in college. I don't anticipate it being an issue. I just wanted to make sure that I'm okay not saying anything to an employer.
Yeah. So, I mean, it sounds like in that case, you know, what the, that you're, you know, yeah, I think that's right. That, you know, it's your right to say, you know, to divulge as much or as little medical information as you want to. So, you know, if that's the approach that you want to take, then it sounds to me like the law might be on your side there.
So if it becomes an issue down the road, and it's, oh, I need to go in for revision surgery or something, I'm protected by not saying, and you know, if it comes up.
Now, one important thing I should add is that the federal disability laws only cover employers with, I believe, 15 or more employees. So for very small businesses, federal law wouldn't apply. State, local laws might, but federal law would not. So that's one big distinction to keep in mind. But let's say that you're applying to an employer that's covered under the ADA. Then I'm sorry, actually, I forgot the question. My apologies.
Just like if the medical, like I myself hasn't been an issue in about 5-6 years.
Mhm.
It doesn't interfere with my day-to-day life at all. If it just happens, you know, if it comes up again, you know, and I haven't said anything to an employer, like, am I protected under by not having said anything?
Yeah, so, yeah, that's a great question. The mere fact that you haven't mentioned it before, or the mere fact that a disabled person doesn't tell their employer about a disability before the symptoms start, or before the disability goes active, that doesn't change the fact that if it happens to become active, and the person needs some sort of accommodations, then they can still get them. So the law doesn't hold it against you for waiting to tell your employer about it. So that's important.
And so if the hydrocephalus becomes active and the person is out of commission and not working for an extended period of time, they can't be fired.
So it depends on whether you're talking about reasonable accommodation or Family Medical Leave Act.
Okay.
So I think that the easy answer to that is that under the Family Medical Leave Act, as long as you're taking leave for one of the protected purposes, one of them is medical leave, then your job should be there when you get back. Okay. And when you come back, that's where disability laws can kick in to protect you from either overly intrusive questions by your employer or from discrimination. Now, your employer, So if you go out for a medical condition and you explain that it's because of a medical condition and you come back, at that point your employer is justified at least asking you for some information about the condition. They might even ask you for doctor's notes, some kind of explanation as to what's going on. Because at that point they know that there's something that might affect your ability to work. So in that instance, it's good to be proactive. And that's something that the law encourages. So if you do end up having to take some leave, whether it's expected or unexpected, it's good to keep your employer in the loop. Because so often cases like this get lawyers involved because the relationship between the employer and the employee breaks down.
Right.
And so it's, on the one hand, you don't want to be divulging personal details unless you have to. You don't want to. People are uncomfortable talking about their medical problems with employers, and that's totally understandable. Fortunately, there are, if you work for a big company, it's usually good practice to engage with HR professionals. So instead of going to your supervisor first, let's say that you think you need to take leave, or you're coming back from leave, or you're on leave and your employer has some questions, it's best to go through HR people first, because they tend to have a little bit more training on dealing with employees, especially when it comes to anything that could implicate discrimination laws, like disability discrimination laws. And their role will be to facilitate. They'll understand confidentiality obligations, or at least they should. And so if you're uncomfortable with your direct supervisor, having kind of ins and outs of your medical history and medical information, then take that up with HR as somebody who's kind of removed from your reporting structure. And they'll have to respect confidentiality. They can share certain information with your supervisors if it's kind of necessary. If, say, you have a condition that tends to manifest suddenly and there actually is a need to keep your supervisor in the loop about it, but they can't share information more than is necessary. There's some nuances there, but that's basically how it works. So yeah, I think that the wrap up there would be just to say that from your perspective, try to treat the process as finding a solution that works for both you and your employer. Because the employer wants you back, they want you productive, and you certainly want to be productive and you want to keep your job. So the process of reasonable accommodation, the process of figuring out taking leave and whatnot, all of that takes place within this kind of intent behind the law, which is to get employers and employees talking to one another about finding a solution that works for everybody.
Very good. So if I go back to your presentation, at the interview point, which we're looking at from here on Tuesday, they cannot ask you if you have any medical conditions.
That's correct.
Okay.
Yeah.
And then
now they can ask you if you can do the job,
right,
or if there's anything that might limit your ability to do the job.
Okay.
So even there, you can talk about it in terms of, well, it all depends on what your particular issue is or what the need is. So you can say, for example, that I don't anticipate there being any problem, or if you think that there could possibly be one, then you can say, well, it hasn't needed to happen in a while, but I might occasionally need to take a little bit of time off of work, just depending on what your symptoms have been in the past. But you can add, you can add that you don't anticipate it happening, and you can also say that if it did, then you're willing to work with whoever to deal with it. But you also don't have to go into any details about the fact that it's medically related.
And then post-hiring, if you've filled out forms and they notice something that you hadn't said, they can't just say, okay, no, we don't want you this and that.
Right. I mean, the employer can't hold it against you that you exercised your rights and kept your information confidential.
Okay. Any other questions? Marcy, nobody posting. Well, I appreciate your time very much so. I think it's been very informative. I hope the folks who have watched live streaming have appreciated how much information I was able to get today. Thank you.
So I hope it's been helpful.
Okay, good.
So many people do not know about this disability. How could a potential employer define themselves explain this to a future employer? So if someone's trying to explain what the condition is, most people, at least in my experience, haven't heard of it. That's a good question. That's a good question.
Yeah, well, and in fact, you might be able to explain better than I would. If you're trying to explain what your condition is, it's best to keep it to, how, what your employer is going to want to know is how it affects you.
You don't want to give them too many details because we go through a process ourselves of learning all about it, and it is a pretty complicated condition. One of the big factors is in between symptoms, in between surgeries many times, is an invisible condition. It's like MS and other things that you really can't point out, and she's a perfect example of this. We're in good shape, but it's always the potential. So again, that was a great question. Go ahead.
Mm-hmm. So your employer will want to know, as you're talking about it, what it is that might limit you as an employee and what you do. Typically when you're describing your condition, try to keep the conversation about what it is or how it is the condition might limit your ability to do your job. But on the other hand, say, well, in that case, here is what I would like to have. And so that's an important point, is as proactive as you can be, as much as kind of a problem-solving mindset, as much as you can do to suggest solutions. Say, well, if this happens, here's what I might come back and propose. That's great, because it shows that you're being reasonable, it shows you're being proactive, makes the employer more likely to engage with you and to give you whatever it is you need to get your job done. And also, if push does come to shove and you have a falling out with your employer and it does end up in a lawsuit, that the more you can show that you are forthright about your condition, that you ask for specific solutions, that you ask for specific accommodations, the better it will make your case, if it comes to that.
It's all kind of common sense, but things that you really should think about, and it's another way of making employers aware of the condition itself, which is we're always ready to advocate for ourselves.
Mm-hmm.
Any other questions?
I think so.
Just one quick note on medical documentation. So a lot of employers these days, kind of as a matter of course, if an employee says, hey, I'm having some trouble, I could use an accommodation, I could use some kind of change of work because of a disability, the employer will want documentation. They can ask for that. That's something that they can do. So a couple of things there. One, it's good to have a relationship with a physician already. One where the physician knows you, knows your condition, and most importantly, knows how your condition affects you. So if if an employer comes back to you after you ask for an accommodation that says, I'd like to see some medical documentation, it is good to go back to them with, either a physician note that doesn't just say, oh, so-and-so has hydrocephalus. It's also good for the doctors, whatever they end up preparing for you, to say, well, here's how, her condition tends to affect her, and here are the kinds of things that would improve her ability to do her job. So that's the kind of thing that's good to present. Not only because it puts the employer on notice of specifically not just that you have a condition, but here's how it affects your ability to do your work, and here's how you can minimize the impact on your work, through offering a certain set of accommodations. But again, fast forward, if things break down, if it goes to litigation, then it means that you have demonstrated, with evidence, with a medical opinion, that not only are you disabled, that the employer should consider X, Y, or Z specific accommodations as a way of making your condition less likely to impact your work.
Excellent. A lot of us go through that in schools in terms of IEPs and so forth, and getting teachers and principals to understand that sometimes accommodations need to be made. Excellent. I thank you very much. I think we're going to wrap this up.
All right.
Thank you for your question from the YouTube channel, and have a wonderful day. Thank you.